Mr. Stewart, I see our discussion revolving around the following dispute. Okay, purpose is the standard. We'll accept that for now. And under patent law, you say there are two and only two ways you can infer that intent from knowledge: inducement and specially equipped things that can only predominantly be used for infringing purposes.
Right.
Is that right?
Yes.
Okay. Well, at common law, there were no such limitations in terms of those two buckets, right? You could infer purpose from a wide variety of things. Are you asking us not to go there?
I think you can still do that with respect to what I would call targeted assistance. That is, if you are providing assistance to a particular person and you're not providing it to anyone else, and you know that person is using that assistance to commit a violation
that kind of
law.
falls into the second bucket under patent law, in my mind. You know, creating or doing something that's only going to infringe.
Yes,
But
yes,
what
exactly.
I'm asking is, okay, under patent law, you're saying those are the exclusive ways you can infer intent from knowledge.
Those are the only ones that are codified in the patent.
Okay, and one could make an argument, because this is an implied cause of action, we should be cautious and we shouldn't go further than patent law. And I understand that argument.
Right.
But if in common law, there were no such two buckets. There were many ways you can infer purpose from knowledge and other acts. So are you asking us not to go there because it's an implied cause of action? Or one might say you could reverse the Fourth Circuit simply for failing to apply the purpose test and go back and do it again, your JMOL analysis, with the correct mens rea.
We're not asking the court to disturb the existing body of copyright law except with respect to ISPs. That is, in Sony, the court noted with seeming approval that there were various lower court cases involving things like dance halls where people were held secondarily liable.
So if I can just summarize it, I'm sorry to interrupt, but so you're saying at least for ISPs we should go no further than patent law?
Yes, and particularly with what I would regard as kind of at the opposite extreme from non-targeted assistance. That is, in cases like Grokster and Twitter, and in this case, we're looking at a pretty narrow subset of aiding and abetting. We're asking, when can a person who provides a good or service to the general public be liable for misuse of that good or service by some member of the public?
Last question then. Why shouldn't we just say, as we might, that the common law required purpose, the Fourth Circuit analyzed it under knowledge being sufficient, reverse, go back and do your JMOL analysis again?
I think you could absolutely do that. And the flaw in the Court of Appeals decision was that it acknowledged the purpose language, but it said, we typically infer a purpose to cause a particular event from knowledge that the event is substantially certain to occur. And I think there are bodies of law where we care more about knowledge than purpose or objective, but there are others where we don't. And for instance, in equal protection jurisprudence, there's a fundamental difference between a state doing something because it will produce a racially disparate impact and doing something for race-neutral reasons, even though it will produce a racially disparate impact.
Thank you, Counsel. Justice